So, welcome back to the next episode of It's Only Human Nature. Let's boil it down. Today, we are going to talk and presume that you have retained your attorney and that we are now deciding what it is that needs to be done. And there's a lot of decisions that have to be made right up front on how to proceed. So, Bob and I are going to talk about some of those today.
Good morning.
And we're going to start with, do you serve the other side?
Well, it's a good question. I think a good starting point is to see if there's a safety issue with your client, if there's been any physical or other types of abuse leading up to them coming to your office. Because if so, you have to contemplate what's called an order of protection.
Okay. So what if you don't serve them? What would you do? How would you start the process?
With a letter, an amicable letter indicating that you've met with the client and that he or she wants it to be done amicably and quickly and without all the litigation that is necessary in some cases.
And what I've done is that I've sent that kind of a letter. I call it my love letter. And it's just a nice way of starting the case so that you're having the sheriff or a special processor go and, embarrass your spouse at work or at home or wherever. But, the other thing I've told clients to do is to maybe take my card and hand it to their spouse if they're on good terms, if there aren't safety issues, and just tell their spouse, have your lawyer call my lawyer.
Mhm.
Here's my lawyer. And, because the idea here is to get the other side to respond and to participate. And how we do that can take, everything from, serving them with a order of protection to just handing them a card, right?
The shot across the bow. Yeah. I had a case once where the husband allegedly stomped on the wife's foot. So the wife went in and got an emergency order of protection. And it was a horrible case from that point forward. The husband never forgave her for the OP.
Right. I've had, I always tell people, let's start nice as we can, okay? Because you don't get a second opportunity to make a first impression. So if you can start nice, you can always deteriorate from there into some aggressive litigation. But if you start with aggressive litigation, it's real hard to back off to being nice.
Yeah, that's true.
And so that's kind of the first thing you have to decide is how do we tell the other side that you have engaged an attorney?
It really sets the stage. And if the other side is not going to play ball, then you've got to get them served.
Right. And that can be difficult. I've had special process servers have to show up with flowers or pizzas or something else and pretend to be delivery people, just to get to them because they're evading service because they don't want the process to start.
Years ago, we had a 71-year-old female process server who everybody opened the door for. Sweet little lady, and you've been served.
Yeah, and that's what you need is just that you've been served, and you can actually even leave it with anybody at the house over the age of 18. So,
Right.
so if you've got an adult child or there's somebody else living in the house, a nanny or whatever it might be, those are people who can accept service, for the person you're trying to serve.
Right.
I've had to go into their places of employment and have somebody serve them there, which is never a good way to start. But if you're evading service, that's what happens. So, I never tell a client to evade service, because let's look at it the other side. Now you're being retained, but your client has already been served. So that's the other side of the coin, is it not?
Yeah, I give the same advice.
Yeah.
Just accept the papers. Let's get it going.
Yeah, let's get it going. There's no advantage to avoiding service. So then we move on. Okay, so now we've either notified the other side, we've served them, whatever needs to be done. And then one of the next questions is there an opportunity for alternative dispute resolution, for mediation, for, potentially arbitration, for things like that? When do you consider those viable options, Bob?
Well, it depends on who you represent. If you represent the economically disadvantaged spouse, mediation's a great way to get free discovery and attempt to settle your lawsuit, divorce case.
Yeah. But there's two types of mediation. There's lawyer-assisted mediation, and then there's where just the clients go. Is that correct?
That's true. I prefer the former.
Yeah. Having especially if you're the economically disadvantaged
For
spouse. If you
sure.
don't have any idea of what's going on, in your husband or wife's business, with the finances, with any of those issues, you can't go to mediation just without a lawyer. You wouldn't have any idea of what you were looking at or doing, would you?
True.
Okay. So now you can decide whether you want to make an offer of mediation. And there's all kinds of mediation services out there. I know I prefer to use some of the retired judges who, have sat in these cases. I think that's a more strategic and, a smarter way to go about it. Do you agree?
Yeah, I found it much more fruitful to use former judges or retired judges.
Yeah.
They get it. They've been there. They've done it. And it's a streamlined process usually.
Yeah, and usually they've set up their offices to accommodate that and that. But mediation can get funny. I mean, I had one where we were we were before a retired judge, and we spent all day. We were there for like 8, 9 hours, and the judge had her whiteboard and had everything written down and what the agreements were, and everything was up there. And all of a sudden the wife looks over and says, "Well, I just came here to talk. I didn't come here to agree to anything."
Mm-hmm.
And I have to admit, I almost went over the table. I mean, it's like, this 9 hours of my life I'm not getting back. But, so I talked to the opposing counsel who had a come to Jesus meeting, as they say, with her client. And, we were able to get it done. But, sometimes people just aren't agreeable, have no ability to settle. Have you found that?
Yes, and it's tricky because mediation is, for the most part, non-binding.
Right.
So you can go through the whole process and get a memorandum of understanding, and it's unenforceable.
Right. And a memorandum of understanding is what the mediator writes up is what the parties agreed to, right?
Allegedly.
Yeah. And that's always the key, isn't it? Allegedly. But yeah, there's some funny things that come out of mediation because we just had one recently where the mediator said, "So what are your goals?" And the wife in this case had come armed with her goals. I want honesty, I want transparency, I want to resolve this fairly. She had everything written down. And, the husband was like, "Get it done." I mean, I'll take whatever, let's just get this done. So, you get different personalities, in mediations that have to be accommodated.
Oh, we have to deal with that all the time, our clients' emotions.
Yeah, right. Emotions. So, and that's something else that I think consideration is what kind of a client do you have that may or may not be capable of participating in mediation. But even more importantly, maybe they're not going to be able to participate in court. You just had a case recently where the client had some emotional issues, which made it very difficult for her to control her emotions, both in court or in settlement negotiations. What do you do with somebody like that?
You got to manage their expectations. You got to manage their emotions. You got to make sure that they're seeing someone and taking care of it on that end of it. And then you got to explain it ad nauseum numerous times if necessary.
I think one of the questions I always ask people as a preliminary consideration is, do you have a therapist?
Mm-hmm.
Do you do that?
Oh, all the time.
Uh,
There's only so much support a divorce attorney can
Right.
provide a client.
And we're at an hourly rate, we're more than a therapist, so they're better off charging paying a therapist than paying us as a general rule.
Agreed, although therapist hours are 50 minutes.
Yeah, that's true too. Ours are
Ours are
a
an
lot.
hour.
But yeah, so, but it's usually at a lot lesser rate, and sometimes it's even covered by insurance. But, what I tell people is I'm not necessarily an advocate for lifetime therapy, but I really believe in situational therapy. So getting somebody in, especially someone who have been emotionally abused or financially abused or otherwise abused, they don't have that confidence, they don't have that they're so used to doing what the other side tells them to do, that getting them to some place where they can build those skills is so important. And I mean, we know therapists in most areas that we can refer people to because it's just such a tool that can be so helpful to going through this because it's not easy.
Yeah, it's gotta be utilized. I just sent someone to a therapist I know, and the therapist called me and said, they're trauma bonded,
Yeah.
which was a new label that I hadn't heard at the time, but it was helpful to the client to understand why she couldn't get out of this marriage, what was holding her back all those years.
Yeah.
She and her husband had all these various traumas going along, and they just relied on each other.
Yeah. There's so much that goes on, as they always say, marriage behind closed doors. You don't know what goes on behind closed doors. We're trying to untangle that all the time. And there's so often a financially lesser involved spouse that are. So what kind of pleadings do we need to file as a preliminary consideration? What would you talk
It
to?
depends. So if I had the economically disadvantaged spouse who doesn't know what's going on, and we obtain some documents, which that's another instruction I give to prospective clients a lot of times. If you don't know what's been going on, get the tax returns, get the bank statements, get the documents over to us immediately.
Right.
And then you can consider if, say, in that circumstance, the husband is spending or moving a lot of the money, you can consider filing a petition for temporary restraining order to seek to restrain, kind of maintain the status quo until you can get a handle on it.
So a temporary restraining order does what?
It would restrain the individual from getting rid of, if you will, the cash or the money in the estate. It would maintain the status quo until you can get the discovery completed.
Okay. And what if somebody stops paying bills? What do we do in that case? What kind of plea?
Petition for support or petition to maintain the status quo.
Yeah. I've seen so often where the kids are the ones who are put in the middle of this because one side or the other just stops paying like bills. So, it can be something as traumatic as not paying the child's school tuition at a private school or a boarding school, not paying their ice skating or equestrian fees.
I just had one where he wouldn't pay the dance fee,
Yeah,
and there was a big recital coming up.
right.
So we had to threaten an emergency petition for dance recital.
And we can file emergency petitions, right?
Yes, they have to be a sudden and unforeseen event, and the judges are sticklers about
They
emergency.
really are sticklers.
And in Lake County, if you file an emergency and it's denied, you're subject to their attorney's fees.
Yeah. Judges have really limited emergency relief. I always tell clients, it's almost like you have to have blood on the floor before you can get an emergency hearing. And that's unfortunate, but what people don't understand is that, in my opinion, is that, their one case and their case is so important to them,
It's the most important.
to their lawyers, okay, to their family. But these judges are dealing with hundreds or thousands of divorce cases every day. And, there's a saying lately about, rich people's problems, one percenters problems, things like that. But, those are real. And, judges get a little hardened, I think would be the word, to some of these money issues because they see the worst of humanity on so many of their other cases, where people are, being beat up or somebody stole the child or, all those terrible things that happen. But to somebody who is in the 1% or does have, significant assets, going into court and saying, pay my client's support when she's sitting on $6 or $7 million in the bank, if that could be a hard sell.
Yeah, that's a separate issue.
Yeah, but it's real to that person. Why do they have to invade their bank account when the other side has all the income and that is what they should be receiving a part of?
Right. Well, as you go along in the process, you pay bills sometimes without prejudice, quote, without prejudice, end quote. And then you can reallocate that at the end of the case.
Is there a way to be a little bit more strategic or savvy in how to present these to judges? For example,
You stump me.
for example, I mean, if you really lay it out, why is this important? Why is this an emergency?
Well, again, you got to get over that hump, and
But-
that's a tough hump to get over. Is what's the sudden unforeseen event? I was sitting in court in December when there were 2 or 3 in a row where lawyers stepped up and there was a dispute about who gets Christmas Eve and who gets Christmas
Right.
Day. And the judge's question was, when did you know December 25th
Right.
was
Exactly.
Christmas? Denied, not an emergency,
Right.
not an emergency.
Right. And there used to be judges, I know in Cook County, used to have literally signs on
the
that
bench.
said Christmas comes on December 25th every year. Okay.
And you got to be strategic about it, because if you lose the emergency, much of the time it empowers the other side.
Right.
They think they won something when you haven't substantively litigated the underlying issue.
And in reality, losing the emergency doesn't mean you lost the motion. It
Right.
just means that you're going to
You get in line
get
and
in
don't
line down
rule
the
on
road.
it when they get to
Right.
it.
So the judge will get to it. It's just that they're not going to get to it today.
Right.
So I know, we had a case recently where, there was an issue of the wife not receiving support. The husband made a significant amount of money, and the judge did, on, a pretty quick basis, order the husband to put at least X dollars into the joint account every month. Is that correct?
Right. That was kind of a hybrid status quo order. Give the money to the wife and then let her pay the bills.
And it was a status quo, which meant that was a number that he had typically
Right.
put into the account. So the judge was comfortable with requiring him to continue to do that, right?
Right.
And support, you would file a petition for temporary support if somebody needed the income to come in, right?
Yes. And so at the beginning of the case, when they get the engagement agreement or immediately thereafter, we send the financial affidavit, help the clients with preparing that, and then file a petition for temporary and permanent maintenance, which is ironic because there's no such thing as permanent maintenance. It's indefinite maintenance.
Yeah.
Because people die, people get remarried.
Right. So indefinite means we're not going to tell you how long. It's just that until there's a further order of court, this can get paid, right?
Right.
Yeah. And so you're filing for temporary maintenance. You would also file for temporary child support, correct?
If there's kids in the issue.
And then temporary payment of other bills, such as the children's expenses, such as medical insurance, such as those things, correct?
And those can be substantial. Hockey, horses, some of the stuff is really ice skating. It's expensive, especially hockey, because the kid's growing.
Even all
So the equipment's like for a year, and then you need new equipment.
Right, skates. So, I mean, but also like the travel leagues. All these kids are in travel leagues, of baseball or soccer or hockey or something. And now you've got, hotels and transportation and all of those things, and usually a parent going along with. So,
And that's all in addition to the child support component.
right. And that's something that needs to be addressed. What about private schools? You've got parochial schools, you've got private schools, you've got boarding schools. How are those addressed?
So the first thing you look at is whether or not the children went to private schools before the divorce was filed. And if so, you try as best you can to maintain the kids and their lifestyle that they had. Circumstances change. Now you have to support 2 households, so it's not always the case.
Yeah. Yeah, I've had issues over, the kids going to parochial grade school. Okay. And then nobody wants to pay for parochial high school. I just had a case recently where what we did is that was something that people don't usually know is that you can use 529 accounts for private schools pre-college
Right.
up to, I think it's $10,000 a year. I'm not sure if they changed that limit, but it used to be $10,000 a year. So when you've got these 529 accounts, you can evade those to pay at least a portion, of the private school tuition,
which can be horribly expensive.
Oh yeah, and that. So if you've got the money the kids should be maintained, and the judges will usually try to do that.
They try.
Yeah. But if there's, sometimes, and I don't care what income level you're at, sometimes people spend all they make and
And then some.
yeah, exactly.
Which is another issue
Yep.
for another time.
Exactly.
Is marital debt.
I remember the first time I saw somebody who lived in like Glencoe, and then I realized the house was mortgaged to the hilt. The car payments were absolutely ridiculous. The credit card debt was ridiculous, but they lived in Glencoe. So there's always, looks can be deceiving. And then when you end up where you throw a divorce on top of people who are kind of living beyond their means a little bit, it can't be supported. So now we have to make some tough decisions, or the court has to make some tough decisions.
Things can get out of hand. I had a case where my client was alerted that his wife was going to start stealing things from the home, so we hired a private investigator to watch outside the house, and virtually after parking right outside the house, a truck came by with the brass downspouts, the doorknobs, the hinges, anything of any value in that house she stole.
Yeah. I had a very similar situation. It was a house out in Barrington, one of those great big monstrous houses, probably 8 bedrooms and 6 bathrooms and everything. And while my client was off on a business trip, the wife stripped it down to the shower rings, on the shower, the shower pole, on took all the toilet paper and the toilet paper where you put the holders, everything. I mean, down to nothing. Okay. And I had to go to a full hearing on getting this stuff back and whether she should be restrained from entering. Well, there's no reason to enter the house anymore.
Right. We litigated ours as well and determined that she sold everything.
Yeah.
So she had to pay him some money back.
In one of our last episodes, we talked about dissipation and how dissipation is the use of marital funds for non-marital purpose. But there's also case law that says dissipation is doing things like that, like stealing the downspouts, like doing those types of things where you can get, compensation for that.
Right.
Destruction of family photos has been found to be dissipation. So those are things, sometimes people threaten I'm going to,
burn it
photos.
down.
I'm going to take all the kids' memorabilia. So many things that can happen that we need to make those decisions. And as we started this conversation, these are the preliminary decisions that need to be made when you first hire your lawyer. Do you need support? Do you need an order of protection? Do you need a temporary restraining order? Do you need whatever else there may be? Parenting, we didn't talk about that, but sometimes if a child is in danger, do you need limitations on parenting? Those are the decisions that need to be made pretty quickly after you hire your lawyer.
That's why it's important to strategize with the client and get all the information, and very important if you're the client to give the information. It's all privileged. Even if you think it's something that's not important, tell your lawyer because it may be.
And it could give you the ammunition you need to get those, the relief. So, yeah, there's been some crazy things with temporary restraining orders. Another example is the one we had recently where the husband was moving all the money out of the country to another country. But
where it was unreachable.
Yeah, well, we went back to the judge and he says, well, I'm not going to give you a restraining order because there's enough other assets here.
Right. Even when you get a restraining order, sometimes it doesn't work because of the ordinary course of business.
Right.
And if the individual has been doing those types of things for a while and there's some pattern of it, then the judges are...
But you're also not going to get a restraining order unless there's no adequate remedy at law.
Right.
And, every judge, and the thing you're going to keep hearing from us episode after episode is every judge is different. What one judge says is valid, another one says is invalid. What one thinks is important, the other one doesn't think is important. So strategize, be savvy, be smart.
Know your audience.
And deciding, that was something we didn't mention, deciding whether to keep the judge that your case was assigned to.
Right.
Be another preliminary consideration, because some judges are pro-men, some are pro-women, some are not good for anybody.
And in Illinois, you're entitled to one SOJ, which is a substitution of judge as of right. You don't need cause.
So you could just say, I don't like the way they look.
Right. they have to grant it.
And they have no choice. You can get the case out of there. But sometimes you have to be careful. The devil you know versus the devil you don't.
You might do worse.
Yes, exactly. So I hope you found this interesting, and we will see you on the next episode.